Go ahead.
All right, reasonable force, corporal punishment. It's very interesting, although I'm not sure that they ask you this, but the Supreme Court, way back in 1977, in Ingram versus Wright, ruled that corporal punishment was not cruel and unusual punishment. And the court has not ruled on corporal punishment since. But in 1993, this you should know, Nevada legislature passed a bill which said that corporal punishment was illegal, ended the practice of corporal punishment in the state's public schools. That was an interesting one because that was one of the few times in my life I went down to the state legislature and testified in favor of that law, because I don't believe that using violence on students is giving them a very good message when we're so worried about violence. The law also specified something you'll all be concerned with a little bit, which is reasonable and necessary force. You can't use reasonable and necessary force, and it lists, and this is supposed to be a multiple choice question, things, and actually a true-false question too. To quell a disturbance that threatens physical injury, to obtain possession of a weapon or other dangerous object for the purpose of self-defense or defense of another person, or to escort a disruptive pupil who refuses to go voluntarily with the proper authorities. The last two are, I have indication from this student, just gave it to me a month or two ago, a true-false and also a multiple choice question. What that says is those are the times you can use reasonable force. However, we're caught between a rock and a hard place, because take the case out at O'Brien Middle School years ago. If you break up the fight, and in breaking up the fight, kid gets hurt, then you can be sued for hurting the kid. If you don't break up the fight, you can be sued because you didn't break up the fight. And so, however reason usually, particularly in Nevada, I'll have to say that Nevada courts tend to be very friendly to educators and to school districts, things like that. More California does not. It's very interesting. Okay, I would just caution you that try to avoid doing that if you can. Try not to lay hands on kids, but sometimes you have to. Okay, we're up now to the top of 27 in the purple, and must be at the top of 34.
Green.
Also, green book. Uniforms and dress code. There's a true-false question on that that says public school districts may adopt requiring students to wear uniforms and/or teachers to follow a dress code. The question would be, the power to do that rests in the school board. So if a school wants to have uniforms at public school, then they have to get the board approval to do that. Student records law, FERPA. I think most of you are probably pretty familiar with this from mainstreaming class, that this Family Education Rights and Privacy Act applies to all students attending institutions that receive federal finance assistance. That's interesting. Just a point of interest is that the main weapon the federal government has against school districts is to withhold federal funding. Now, there are school districts who are quite wealthy that have chosen not to accept any federal funding, and so therefore then that sort of protects them from the federal government going after them. But like in special ed, if a kid needs special ed services, and the school district isn't getting any funds for special ed services, the parents can still sue the school district because the kid has a right to those services. So that probably confused you more than anything else. Basically, the FERPA is the right to review for parents, review records. We really needed that. School records used to be a disaster. There's all sorts of things. Joey is a total jerk. There are all sorts of stuff written in files that need to be cleaned out. And also, the school is required to explain to the parents that they have the right to review the records, and if they believe records to be inaccurate or inappropriate, the parents have the right to have it expunged out of their record. Now we're over to 35 in the green book, still at the very bottom of 27 here in the purple book. The law deals with custodial and non-custodial parents having equal rights to student information unless the school has evidence of a court order or a state law revoking those rights. So someone who has custodial rights has those rights. When a student reaches 18, like I said before, the student becomes a individual, and the rights for FERPA transfer to the kid. So not only when a kid turns 18, they have a right to look at their, up to that time, the parents had the right to look at the file. The kid didn't actually have those rights. As soon as they turn 18, they do. As soon as they turn 18, they're adults, and that means they can sign their own excuses. I had a mediation case in South Las Vegas in the Napa Valley where a parent filed to have their kid given more special ed services and some other things like that against the school district. The interesting thing was, when I got the paperwork, I looked at it, and the kid was 18. So I picked up the phone and called the kid on the phone and said, "Did you know that your parents filed this?" He said, "No, I didn't have a clue." I said, "Well, you're over 18. You have the right. Do you want to pursue this?" And he said something, "No, blank, 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 no, I don't want to pursue that. Well, they just leave me alone." And so I called the parents in the school district back and said, "I'm sorry, the kid has a right to do that. That's the way it is." It's interesting. Okay, on
45 seconds.
page 28, it talks about directory information, which are things like name, address, telephone number, other information. Those can be released by the school. The parent can and should be given the opportunity to tell the school not to do it. And that's basically that.